have distinguished professor at Touro University, Thane Rosenbaum. Also with us is constitutional law attorney and Newsmax contributor Amir Benno. And of course, our special guest today, constitutional attorney Andrew Lieb. Gentlemen, appreciate you all being here. A lot to break down. Amir, I want to kick it off with you. Obviously, this was almost a week ago that the former president announced that he had received a target letter, that he was part of this special investigation into Jack Smith. Talk to me a little bit about the charges that we are expecting. Really interesting to break down these charges, given the fact that the last one, is actually a statute that was enacted following the Civil War to prosecute individuals who would prevent former enslaved African Americans from voting, but today is used in voter fraud cases. All of this, of course, related to attempts to overturn the 2020 presidential election.
Yeah, well, good afternoon. It's great to be with you. So the charges that we think are coming are conspiracy to defraud the United States. There's going to be problems with that because in May, the Supreme Court rendered two decisions on what fraud means. And instead of letting prosecutors use that word to sort of expand it to cover all sorts of different things, they said, no, fraud is when you essentially take somebody's property or money. And this was not like a fractured decision. This was a unanimous Supreme Court saying this. So if Jack Smith thinks that he's going to be able to prevail on a criminal charge of fraud, I think that's going to fall flat. The second charge is the corrupt obstruction of an official proceeding. It's unclear whether he's basing this on the riot at the Capitol or at some sort of interference with just the counting of electoral votes. But again, the word corrupt is one of those phrases, like I said, with fraud, the Supreme Court's not going to give broad license to the prosecutor to expand. And so I think he may have problems with that. And to the last one, which you mentioned, Kilmeny, which is conspiring to deprive citizens of the free exercise of their constitutional rights. Even though this is a Reconstruction era statute, this is a sort of statute that the Civil Rights Division of the DOJ uses pretty routinely, but usually to prosecute individuals like Derek Chauvin when they act one-on-one to violate somebody's constitutional rights, say their Fourth Amendment rights. It's never, to my knowledge, been used to the entire voting public writ large. And so he's pursuing a novel legal theory, which he has done in the past, and he's been smacked down by the U.S. Supreme Court for doing it. But again, I think he's going to run into some challenges with that.
I have to confess that I made a personal phone call to Thane yesterday asking him when this is going to happen, when we're potentially going to see a third indictment. We've all been on indictment watch all week. Thane, you had some interesting thoughts for me about the nature of this case and how things may evolve from here. Please share that with our viewers.
So, Kilmeny, I've always thought that the January 6th case was the weakest case against Donald Trump, which is why when they went with the documents case first, that made sense to me, because there may be something with the mishandling of documents. The January 6th case, remember all the testimony that they heard on the select committee in Congress about incitement to riot, about seditious conspiracy. I heard Amir lay out the potential indictment counts. I didn't hear him mention that because Amir is usually right. I can't imagine that they would use the incitement to riot. The president has a right, First Amendment right, to engage in political advocacy. Seditious conspiracy with whom? The Proud Boys, the Oath Keepers. There's been no evidence that there's been any direct or indirect contact with them. And the point, let me add something to what Amir said about obstruction of a federal meeting. Here's something that I recently discovered. It's never been used for mobs and riots. The law is for corporate malfeasance to prevent corporations from destroying documents or tampering with witnesses. Some of the 300 people that pled guilty to the obstruction of a federal meeting in progress, they're appealing that case. The Supreme Court might even see it. So the one case, the only thing I can think of is maybe the pressure campaign against Mike Pence. But again, its intent matters. If President Trump truly believed that the election had been stolen, that's a question for the jury. And so I'm not sure where they're going on January 6th. Again, I always thought it was the weakest of all the cases.
Andrew, what do you make of the former president's legal strategy at this point, given the fact that he was invited to testify and clearly declined this week?
He was given those 4 days to remind you back from when he got the target letter on Sunday, which he told us all about. And generally, you'd be out of your mind to go testify before a grand jury. No one would go testify. It doesn't happen. It didn't happen when we were dealing with the case down in Florida with the federal prosecutors. But I think the issue here is that President Trump likes to have such a megaphone, and he likes to go and be on Truth Social every minute of every day and give us the play-by-play. So frankly, I was a little surprised he didn't steal the podium, go and testify. It would be unorthodox, never happened, but for him, everything unorthodox is orthodox. That's how the Trump playbook goes.
All right. Amir Benno, Thane Rosenbaum, and of course, Andrew Lieb will be sticking around. Great to have you all on. Thanks.
Thank you.
Thank you.